How does Sharia law affect estate planning? Have you ever wondered how Sharia law influences the way estates are planned, especially for Muslims? Understanding this can be essential for anyone involved in estate planning. Sharia law, derived from Islamic teachings, sets specific rules for how a deceased person's estate is distributed. This significantly impacts estate planning for Muslims, especially when considering international contexts and offshore assets. One of the key principles of Sharia is the fixed share system. This means that each heir receives a specific portion of the estate based on their relationship to the deceased. For example, sons typically receive twice the share of daughters. This fixed share system, known as faraid, is outlined in the Quran and must be strictly followed in any estate plan that complies with Sharia. Another important aspect is the wasiyyah, which is an Islamic will. This document is crucial as it outlines how assets should be distributed according to Sharia law. It ensures that the estate plan adheres to the fixed shares while also allowing for charitable giving or specific bequests, but only up to 1/3 of the estate. Unlike secular estate planning, where individuals have more freedom to distribute their assets, Sharia imposes limitations. Only 1/3 of the estate can be allocated by will to non-heirs or for charitable purposes. The remaining 2/3 must be distributed according to the fixed shares. Before any distribution occurs, all debts and funeral expenses must be settled from the estate. This is a religious obligation and part of proper estate management under Sharia. Additionally, Sharia law requires appointing guardians for minor children or dependents. This ensures that their care aligns with Islamic principles, which is a vital consideration in estate planning. For non-Muslims or individuals living in countries where Sharia is part of the legal framework, estate planning can become complicated. Some jurisdictions allow non-Muslims to opt out of Sharia inheritance rules and apply their own laws. However, Muslims living in non-Islamic countries often need to reconcile Sharia requirements with local laws, especially when dealing with offshore assets and international estate planning. In countries like the United States, probate laws may grant spouses or heirs shares that differ from those prescribed by Sharia. Therefore, it is essential to have proper estate planning documents, such as trusts and wills, that align with Islamic principles while also complying with local laws. Muslims engaged in estate planning should work with legal professionals who understand both Sharia and the relevant civil law. This collaboration helps avoid disputes, maintain family harmony, and fulfill religious obligations related to inheritance. Overall, Sharia law imposes a structured framework on estate planning that prioritizes religious mandates on inheritance shares and asset distribution. This structure must be carefully integrated with the legal environment of the individual's country of residence and any international considerations.